Good evening, everyone. So it is very nice to see you all at such a short notice. Wherein we have assembled to discuss the recent landmark judgments by the Honorable Supreme Court of India impacting the charity sector. Uh, Friends, there are two very interesting rulings which were pronounced by the Supreme Court on 19th of October 22. So the first ruling is in the case of New Noble Educational Institution. Citation is 143 Taxmann.com 276. And this ruling is in the context of educational institutions approved under Section 1023C VI. And another very important ruling, which is in the case of Ahmedabad Urban Development Authority, 143 Taxmann.com 278. And this ruling is about the definition of charitable purposes, and it specifically discussed the last limb of the definition of charitable purpose, which is advancement of general public utility, that is GPU. So to the extent time permits, we will discuss the principles coming out of both these judgments in our today's discussion. So the ruling one, which is on the in the case of New Noble Educational Society, so it primarily discusses Section 1023C VI, and this section provides an exemption to educational institutions which are approved by the Principal Commissioner of Income Tax. So in this section, there are mainly the 5 things. First one is this exemption is to the university or educational institution, and this institution should solely exist for the educational purposes. And another important point is it should not exist for the purpose of profit. And it should be other than those under III AB and AD, which are below the threshold limit of 5 crore and wholly or substantially financed by the government. And these institutions should be approved by the CIT. So herein the court has analyzed the meaning of educational purpose and what is the meaning of not for the purpose of profit. And court has also overruled very important rulings in the case of American Hotels and Queen Educational Society. But the court has also made a very important and interesting point here is that this interpretation shall apply prospectively to avoid the disruptive effect. So in a way, court agrees that this ruling shall have a disruptive effect. And now coming to the second ruling, which is in the case of Ahmedabad Urban Development Authority, wherein the court has discussed about the GPU, that is advancement of any other object of general public utility. So the court has discussed about the proviso to 215 and 11(4)(a). So we will discuss all these things in today's session. Now I invite Dr. Fogla for his remarks on these rulings.
Thank you, Tarun. So now Tarun has already given the context, but why we have gathered under such a short notice is the far-fetching implications this might have into the organizations, and the rulings have come more or less exactly mid-year, and these rulings are prospective. So organizations may have to take remedial measures, even though they are not retrospective, but there would be various kinds of effect. But why these rulings are confusing, let me just in a nutshell share some pointers, then we will go into the provisions, and then we will try to address some of the issues which come to our mind in the context of this ruling. One, these rulings are confusing particularly because even prior to the rulings, the provisions were confusing. We always struggle to understand that what is business activity under Section 215, proviso to Section 215. What is business under Section 11(4), that is property held at as business of trust, and what is business under Section 11(4)(a). So basically, if I see this, both the rulings have the same ratio. The ratio is not about solely educational institution or a general public utilities institutions. So there are two groups of institutions against which the ruling. But the undercurrent of the ruling is that gone are the days when we used to say that any activity will be said to be incidental if the money is used for charitable purposes. The court has said no. No incidental business activities, no activity will be treated as incidental business activity unless it is directly related with your activity. For instance, you are providing hostel facility to your own student, seminar facility to your own student in case of educational institution, and so on for other institutions. So whether it is a general public utility institution or a solely educational institution, now the Supreme Court has categorically said that one, there is nothing called a business activity as a part of primary advancement of objectives. So as a part of primary advancement of objective, if there is some activity, that is section 215 in case of any other public utility organizations, and 7th proviso and 11(4)(a) in case of solely educational and medical institutions. So if you are engaged in any activity which is commercial in nature towards advancement of your objectives, then for any other public utility, the quantum of such activity should not exceed 20%. And for other first 6 limbs, this 20% limit will not apply, but for all practical purposes, the scope for incidental activities has been drastically reduced, and most of the activities, many organizations which are conducting, they have to stop these activities. So now what is there? Incidental activity is extremely restricted. The organization has to establish that it is directly related with the business, with the advancement of the objectives. And 11(4)(a) means incidental activities. Incidental activities will not be calculated anywhere. We cannot say that in our main objectives we have commercial come charitable activity. For instance, in some cases earlier it was decided that one can charge more money to NRI students and less money to general students and cross subsidize it. So now court practically is saying that if there is a portion of activity which is with profit motive, take it to 11(4)(a), take it to the 7th proviso, maintain separate books of account. There is nothing called commercial or with profit motive activity as a part of the primary objective. And under 7th proviso, that is incidental business activity, or 11(4)(a), incidental activity is extremely restricted. So for instance, educational institution doing consultancy activity, educational institution allowing their infrastructure for seminars, educational institution taking GST registration and giving various courses on commercial basis to non-students, except there is a rationale to establish that it is a part of their primary educational activity, all these activities will result in withdrawal of exemption. The assessing officer will be empowered to withdraw the exemption, and the commissioner will be empowered to deny the registration itself. So this is the primary. The more important issue is the redefining of the word incidental. The court is very clear. We had very landmark rulings in Thanti Trust, Gujarat Maritime, even recently last year in Delhi High Court in Servants of Society case said that if the money is used for charitable purposes, the business should be treated as incidental. Supreme Court has clearly said that such businesses are businesses held as property of trust, and they can only be covered under section 11(4). And an organization cannot conduct any business as property of trust. Practically, 11(4) business, that is income held as property of trust, that is 11(4). Income business incidental to activities, charitable activity 11(4)(a), and 20% business activity section 215. So everything now is under two categories. 11(4)(a), only incidental activities, extremely restricted, and 11(4), only those businesses which were settled by the settler. It is not that you can create the businesses. So 11(4) also again very restricted. So this is the primary implication is on incidental business. And in primary activity, there is nothing called a portion of the activity with profit intent. It has to be separately accounted, separate books have to be maintained, and you have to declare it under 7th proviso or 11.4a. So this is the undercurrent of both the ruling, but these two rulings are diametrically different. And we have analyzed some provisions, some main provisions, mainly out of this novel education case. And we will run through, I will request Suresh ji to take up step by step. In between, we'll discuss the issue arising out of it. Suresh ji.
Thank you, Manoj ji, and thank you, Tarun ji, for setting the tone for today's discussion. Let me share my PPT. तरुण जी आप बताइएगा वो आया कि नहीं ठीक से? तरुण जी चल रहा है मेरा PPT?
हाँ PPT विजिबल है सर, प्रेजेंटेशन मोड पे कर सकते हैं आप फुल स्क्रीन.
अभी चला नहीं ना?
हाँ अभी प्ले नहीं हुआ.
अब देखिए.
Yes, perfect.
Okay. So just to run through the one slide for the concept, we all know there are two parallel regimes. One regime is section 1023C and another regime is section 11.2.13. And 1023C, we know there are two non-approval category and there are approval category. So, and again in the approval category, there is section 1023C6 that deals with education and that provides that any university or other educational institutions existing solely for education purpose and not for the purpose of profit and approved by the commissioner, then the income shall be exempt. So one of the case, the novel case deals with this particular class of NGO, this particular class of educational institutions which are approved under section 1023C6. Whereas section 11.12.13 deals with that the income from the trust properties shall be exempt to the extent applied for charitable and religious purposes. And here there is no restriction on the soleness of the purpose. It can be any purpose depending upon the charitable purpose as per section 215. As already informed that there are two landmark judgments. One is the New Noble Education Society and another is Ahmedabad Urban Development Authority. Both came on 19th of October. And it is also mentioned that the Noble Education Society case deals with 1023C6 exemption and Urban Development Authority deals with proviso to section 215 and the business-like activity. My PPT I shall basically run based upon the New Noble Education Society, and in the case studies, we will refer the decisions of Ahmedabad Urban Development Authority as well. Now, this session will cover the understanding of the meaning of solely education, the impact on incidental business under the 7th proviso to section 1023C and section 11.4a, then power of commissioner to examine books of account and to check compliance with other laws while granting approval, and applicability of ratio of judgment of Naval Education Society to a 12AB registered NGO, because this Naval Education Society judgment is for 1023C6, but the judgment is pronounced and the ratio of judgment may equally apply to a 12AB registered NGOs. Now, understanding the meaning of solely education. The income of any university or other educational institution shall be exempt from tax under this provision on fulfillment of the following conditions. It exists solely for education purpose. It doesn't exist for the purpose of profit. It is not wholly and substantially financed by the government. Its aggregate annual receipts exceeds with 5 crore, and it is approved by the principal commissioner or commissioner. So this is the basic conditions for 1023C6. Again, what shall be the meaning of education? We all know section 215 defines the education purpose, the purpose of charitable purpose as relief to poor, education, yoga, relief, medical relief, preservation of environment, preservation of monuments, and other general public utility services. Again, the Income Tax Act nowhere defines any of the purposes, and it is the judicial pronouncements based upon which we understand what is covered under education and what is covered under yoga and what is under medical relief. And for the word education, has not been used in 215 in the wide and extended sense, according to which every acquisition of further knowledge or constitute education. That means every acquisition of knowledge will not constitute education for the purpose of 215. For the purpose of 215, what education connotes in that clause is a process of training and developing of the knowledge and skill mind and character of the students by formal schooling. So any education system through formal schooling is a landmark judgment of sole trustee Lok Shiksha trust case. And this judgment in New Novel Education Society has also mentioned this while defining the education. So education basically means a formal education, formal schooling, education through formal schooling. Again, we have to understand the meaning of the sum solely. The basic provision granting exemption is when the education should exist solely for education purpose and not for the purpose of profit. The expression solely has been interpreted so far as per the other judgments as the dominant and predominant and primary and main object. That means the education should be a dominant or predominant or primary object. But the court says that the plain and grammatical meaning of the term sole or solely, however, is only exclusive. Again, they define the solely means exclusively and not primary. The Chamber Dictionary, the court has mentioned that the solely word is only and not involving anyone or anything else. Again, they have gone into the further definition of the meaning of the solely, alone and independently, single-handed, singly, unaided, unassisted. And that means, and based upon this, they are saying that the decision in American Hotel and Queen's Education Society did not explore the true meaning of the expression solely in the context of the education institution. Instead, the principle applicable test administered in Surat Art case as a predominant objective test was applied in all the cases relating to the charitable institution coming to impart education. So they are saying for the term solely cannot be dominant. It has to be only. That means the term solely depends on when the society and when the education institution is existing only for education. And they cannot be a dominant object or they cannot mixing of object. So the ratio of this definition from the Supreme Court is that the term solely is not the same as predominant and mainly. The term solely means to the exclusion of all other. Therefore, a solely education institution can no longer engage in any other charitable and non-incidental business activity, means non-incidental education activity. Manoj, you can.
So, sir,
Tarunji, you can.
Yes. So there was a landmark ruling, as we have mentioned, the Loka Shikshana Trust 101 ITR 234, wherein the Supreme Court has defined the meaning of term education. And from the very beginning, the word education has remained a subject matter of debate. As in the charity sector, this word has been used in a very limited sense and not a wider sense. So what will be the impact of this noble ruling on this Loka Shikshana Trust, since the term education as defined in Loka Shikshana Trust has got mentioned in the ruling of Noble Trust as well? And will it be confined to the formal education? Will it have impact on the short-term courses? Or also one thing to add here is, will it have a limited impact on the 1023C VI? Whether it will also impact that charitable trust which are taking the benefit of exemption under 11 to 13 and which have their purpose as education.
And what we understand and gathered after reading both the rulings is that the court has not gone on to define or give a new definition to the term education. It has referred Lok Shiksha Niketan and various other Supreme Court judgments where education has been defined. The focus of this judgment was that to understand education in a holistic manner in the sense, though Lok Shiksha Niketan said that education itself should be formal education, something which results in a degree, which is connected to the long-term studies of a person, or it results in degrees from recognized institutions, universities. But this definition of education was somehow diluted due to the leeway allowed by other cases where they said that if the organization is doing formal education, if it is doing some training courses, if it is engaging in some other activities, they will form a part provided it is dominantly an educational institution. So the problem is that now this dominant word has been challenged. So the formal education, there is no change. The organization will be educational organization if it follows law section and it is doing. So there is no change about. But if it is dominantly educational, dominantly formal education, it can claim benefit under 1023C and it can claim benefit other. So now the difference is that now it has to be absolutely educational, not dominantly educational. So the other incidental, non-educational activity or quasi-educational activities which don't fall under the law section definition will not be covered under the definition as an additional activity in addition to the dominant activity, which was till now covered. Secondly, any profit making or revenue generating activity cannot be done by the educational institution as a part of advancement of its objects. And no activity other than which is required for advancement of objective can be done for the purposes of business. So an educational institution should do only those businesses which are integrally required. It can run a mess, it can sell books, it can run hostel services. These are the kind of things the court have treated that this could be possible business expenditure. So in that sense, the problem is with the word dominant. Earlier, we were dominantly formal education and we were doing various other activities. But now, being a dominantly formal educational institution will not be enough. You have to be an absolutely educational institution. So that is the problem. So even without making any change in law section ruling, the court has created very wide-reaching ramifications for all existing educational institutions. Now coming to educational institutions which are taking the benefit under section 12A, 11 to 13. So the impact of this ruling is that educational institution may not be absolutely educational institution under 12A, but they have to be absolutely pursuing the objects under which they are registered. And they similarly, they cannot claim any incidental activities, and their incidental businesses should be exactly and directly relevant. So solely means exclusive. Incidental means incidental to the principal activity. It cannot be a feeder. It cannot be an activity which feeds or provides income to the main activity. So these are the two major changes. So under section 12 registered organization, the issue will be they don't have any financial limit if they are educational relief to poor, suppose, or only educational, but their incidental activity will be computed under 11.4a, and 11.4a they have a very small window of incidental activity. So this will be the implication. This running short-term educational courses, what we can say that this again is a debatable issue. So we cannot say that educational courses. What we can say that the courses which are recognized by authorized, recognized, approved regulators or institutions, they have traditionally been treated as educational courses. Sometimes even a vocational course by a regulator or some offbeat course, even a music course, but it should lead to a particular degree through a recognized body. All other courses under law section were not treated as education. So that is one area one has to go into case to case, bit by bit. We cannot take a just general call.
Thank you, Manoj. The next important issue dealt up with by both the decisions is the incidental business activities, which Manoj has dealt upon with to some extent. Now, this Noble Education Society case, they are what they are holding. They are holding that the 7th proviso of section 1023C6 alludes to business and profit, being profit and gains to business, unless the business is incidental to the attainment of its objective, and separate set of books of account to be maintained by it in respect of such business. So both then section 1023C6 proviso allows that the business-like activity can be undertaken provided it is incidental to the attainment of main objective. And interpretation of section 1023C, therefore, is that the trust or education institution must solely exist for the object it professes, in this case, education and education activity only, and not for the purpose of profit. And therefore, the seventh proviso, however, carves an exception to this rule and permits the trust or institution to record or earn profit, provided the business which has to be read as education, because the proviso says business, but they are saying as because they are solely existing for the education, the word business shall be replaced by or should be read as education and education activity and nothing other than that. That incidental to the attainment of main objective, that means they have made it very categorically clear that the business is a general term. If you are solely existing for education, your incidental activity has to be with education. And for the NGOs registered in section 11, 12, 13, if you are existing for some other working for some other purposes, your incidental activities should relate to that purposes for which you are pursuing. So the seventh proviso to section 1023C as well as section 11.4a refers to the profit which may incidentally generated or earned by the charitable institutions. In the present case, same is applicable to those institutions which impart education or are engaged in the activities connected to education. The reference to business and profit in the seventh proviso and section 11.4a merely means that the profit of the business which is incidental to the educational activity. Though this judgment was in reference to section 1023.6, but while pronouncing this judgment, they have also make a reference of section 11.4a, and therefore I feel the pronouncement of incidental business activity is equally applied to 11.4a, and this is again clarified by the other decisions on this issue. Where institution, and therefore they have also given an example where institution provide their premises or infrastructure to other entities, trusts or societies for the purpose of conducting workshops, seminars, or even educational services, which the concerned trust is not actually imparting, then and outsiders are permitted to enroll in such seminars, workshop courses, etc., then the income derived from such activity cannot be characterized as a part of education or is incidental to the imparting education. Meaning thereby, if the students for which you are imparting formal education, if you in your other program, they are not the person to be benefited, then those part of the activity will not also be education and neither it will be incidental. So incidental has to be connected with your primary objective of education. The ratio coming out of this judgment is imparting education through a school, college, and other institutions would be per se charity. Apart from that, there could be activities incidental to providing education only. And one example may be the sale of textbook to the students.
Sir, as we understand earlier, there were mainly used to be three business categories. One was under proviso to section 215. Then there was business held as trust property. Then comes incidental business under 11.4a. But I would like to ask this question not only in the context of educational institutions, but I could see many questions in the Q&A box as well. What will be the incidental business activity relating to the main activity? Since we see there are Kalyan Mandaps, since we see there are marriage halls run by the religious organizations, what will be the overall impact of this judgment on these organizations and what will be considered as incidental activity?
As we see these two judgments, it seems that the court has taken a very strong view. Basically, the court is saying that if a charitable organization or a religious organization, whether falling under educational or general public utility or any other category, if it is engaging in any kind of business, directly or indirectly, with the intent of making profit, then the exemption should be denied unless such charitable or religious institution establishes that the business was integrally necessary to carry out the main objectives. So now basically the onus is on the institution. The educational institution has to bring out and cause. So the court has said that suppose you are providing hostel facilities, normal hospital facilities, we don't treat it as an incidental business. So, but court has said that certain ancillary activities which are required, suppose fooding facilities given to pilgrims in a religious hospital, staying facilities given to only the pilgrims for a religious institution. These are the kind of activities which could be incidental business activity. That means it should have a direct link with the implementation of your program. It should have a direct link with beneficiary if you have beneficiaries. So incidental business activity for educational institution in Assam, education state board case, it was held that printing and publishing of books was education. So now the court said that it was in that context that it is directly related with educational institutions. So it is not necessary that you are independently imparting knowledge. For instance, in Adityanar education, Supreme Court said that even if you are a mother organization, not giving education directly, but you are developing child organizations. So in that sense, the idea is this: whatever you have to establish, whether the charitable activity or the business activity, it should have a direct link with the primary activity. Some examples which the court has given: hostel facilities. The court has even gone on to say that suppose your infrastructure is used by a seminar for persons who are not your beneficiaries, it will not be treated even as incidental business activity. So you are not eligible to claim it as incidental business activity under 11(4)(a). Then the commissioner can say that you are working for profit motive and you cannot sustain 12-way registration. So to that extent, this ruling seems to be severe in defining the word incidental.
So, sir, it says that activity should be directly linked with the main activity, but can this result into a surplus or profit?
No. Business activity are supposed to be carried out with the intent to make profit. The court has clearly very said that look at section 215. Section 215, advancement of activity. So if you are an educational institution or a relief to poor institution, if you have taken 12-way registration, you will do only relief to poor activity. You will not do anything. Suppose while implementing relief to poor activity, you are compelled to do some business type activity. Then the quantum will not be 20% because it is not the 7th. If it is a GPU category, general public utility, the quantum will be 20%. And while implementing your general advancement of general public utility or relief to poor activity, if you are doing some activity which is commercial in nature, then maintain separate books of account. That means there is no commercial activity or profit making in the advancement of main objects. Separate books of account and direct relationship with the activity. If you are failing to fulfill these two conditions, then you will be treated as an organization ineligible for section 1023C or 11 benefits.
And sir, in the Ahmedabad case, they have said that 215 has to be harmoniously read with that 11(4)(a). So that 215 activity has also to be within the corners of that 11(4)(a). That is the understanding.
It is very important because for there the court has said that 215 has gone too many changes since 2008. And in 2016, I think the final change came when the two proviso were made and 20% limit was set in 2016. The court says all old decisions, Thanti Trust, Gujarat Maritime, were given when 215 was in its old shape. So the current 215 doesn't provide any scope for any non-incidental business activity. 215 clearly says that an advancement of general public utility, if while advancing its main object is doing some activity. Why the court said 215 is that in Surat Art Silk case, the question of law before Supreme Court was that apart from the trade association's members benefit the association was working, there were some clauses where the association could export some materials or import some material where it could generate. So then the court said that because it was charitable in nature, helping the industry, if it is doing some incidental business activity, it will be treated as a charitable organization. It will not become. This is Surat Art Silk case. So now the court is saying that Surat Art Silk case, how to implement is very clear in section 215. 215 says that suppose you are a trade association. So you are working for your industry trade members. You are conducting seminars, symposium, everything should be charitable. Suppose you are doing some business, you are doing some export, some import, some trade exhibition where you are charging fee or some others are participating, whatever. Then you the limit is 20%, maintain separate accounts, and the income will be used for charitable purposes. The court says there is no concept of a charitable organization doing any kind of business activity. Earlier in Gujarat Maritime and all other cases, it was held that the charitable organization is doing various kinds of business activities and using it for charitable purposes, it can claim that it is incidental. So these two rulings are saying that these are based on old rulings which are redundant. These rulings were made when 215 was not amended. Antitrust is 1992, Gujarat Maritime sometime in 2000, prior to the amendment of 215. So therefore, the implication is very clear. Any organization, any limb, incidental activity will be permitted with profit motive. You have to maintain separate books of account. And there is no limit for other organizations, but if the limit becomes disproportionate, then the dominant profit motive will take away. Suppose an educational institution is doing 40% of commercial activity because the limit does not apply. So 215 proviso does not apply. But if it is established that overall it is having a dominant profit motive, then its genuineness under 12A will be under question. So there it will lose. So it is not that a educational or relief to poor organization can do more than 20%. It is not that simple. It is a technical thing. Basically, no charitable organization can engage in any kind of business activity. It is absolutely necessary. It is absolutely incidental. Maintain separate books of account. Show it under 11.4a or 7th proviso, irrespective of what type of organization you are, and that profit you plow back. To ensure that there is no activity which is not incidental to the purpose for which you have given 1023C or 12A registration, whether the purpose is general public utility, relief to poor, education, it would not make any difference. Only in case of solely educational institution, the word solely is absolute, and they have to be very careful. They have to weed out even a little bit of any other activity.
Thank you, Manoj. The next key ruling is the power of the CIT to examine books of account and other compliance with other laws while granting approval. Very, very key amendments, key judgment. Now they are saying, so far, because as per the American Hotels case, that the commissioner at the time of granting approval, they can only verify the object clause, whether the activities are, whether the object clause are suggesting the genuine activity or not. But in whatever verification of accounts, it should be done at the assessment stage and not the stage of granting approval or granting registration. The court says, while that reasoning undoubtedly applies to newly set up charities, they are saying that for the newly set up charities, yes, there is no point going to the accounts because the activity has not yet started. But this provision of approval also applies to existing entity as well. And for the existing entities, the court says the power of examination shall apply even the accounts. And again, they are saying the commissioner authority is not in any manner constrained from examining accounts and other related documents to see the pattern of income and expenditure. But the commissioner or concerned authority, while considering an application for approval and the further material called for, should confine the inquiry only to the nature of the income earned and whether it is for education or education-related objects or the society. Because now they have to see whether you are existing solely for education. And that's why at the time of approval, at the time of renewal of approval, or the time for existing organization going for the approval, the commissioner has within its power if we seize the account to see the income pattern and whether all the income is either from the education or from the education-related objects before granting the approval. Again, the court is saying if the surplus or profits are generated in the hands of the assessee applicant in the imparting of education or related activities, disproportionate way not to be given to the surplus or profit, provided they are incidental. At the stage of registration or approval, therefore, focus is on the activity and not on the proportion of income. If the income generation activity is instinctively part of the education, the commissioner or other authority may not on that basis alone reject the application. So basically, they are also saying your incidental activity income may be more, but at the time of registration or approval, they will not go into the proportion of the income, but they see all the income raised from the education or the education-related objects. Now, the second, the ratio coming out from this judgment is, in the case of granting approval for an existing organization, the commissioner has the power to examine books of account to verify the nature of income earned and whether it is for education or education-related objects. Now, the second important power of the compliance verification at the time of granting approval is, an education falls within the scope of charitable purpose, both under 2.5 of the Andhra Pradesh Act, as well as 215 of the Income Tax Act, because the case, in the instant case, the trust was, the education society has not been registered under AP Act, as required under the AP Act. The court held that the chief commissioner was justified in holding that the petitioner societies should have been registered themselves under the provision of AP Act, as failure to do so would have resulted in one arm of the law being utilized to defeat another arm of the law, which would not only to oppose to public policy, but would also bring the law in ridicule. So they are saying the government, the commissioner has under every power to see whether any state laws applies to that trust and whether the trust has registered in that act or not. The ratio coming out from this judgment is the commissioner shall verify the compliance of other state laws while granting approval. Manoj,
Sir, as of now, once we apply for the registration, the commissioner also sees the genuineness of activity. So to determine the genuineness of activity, they generally ask for the related records. So what will be the impact of this judgment? Like, can they check the books of accounts by following the ratio of this judgment?
Again, 12-way registration in the past has been a very debatable issue, and there have been issues both where the revenue felt that their power are constrained and the organizations felt that their registrations were rejected arbitrarily. So in 12-way registration, if you remember, throughout the country, many Commissioner of Income Tax used to issue letters saying that the amendment interest deed will be approved by the commissioner, and there should be a clause regarding various things. So last year, CBDT issued a circular directing all the income tax commissioners issuing 12A and 12AB registration to follow the conditions which are specified in the Act itself and not to ensure. And on the other side, there were cases. There were cases where at the time of 12-way registration, the Commissioner of Income Tax found that benefit were given to interested persons. Income tax officer found that there were some contentious entries in the books of account. And the courts and tribunals held that these are assessment issues. And there is no business of the income tax commissioner at the time of registration to go into these issues. Even if it comes to the notice of the commissioner, the 12-way registration has to be given. This judgment puts to rest this latter part of the debate and the question mark on the powers of the Commissioner of Income Tax, because the power was not very well articulated in the section 12AA earlier and 12AB now. So how should the commissioner decide on the genuineness? So the genuineness is the credibility, the registration. It is registered under section. There is a case law which says that if the organization is registered under section 8 or section 25 of the Old Companies Act, that itself is good enough for the commissioner to give 12-way registration. So that is enough for registration. Now this judgment is clearly saying that except new organization, if you are a new organization the commissioner will follow all the old norms. He has to just give you registration. He cannot suspect that you will not do activities in future. But all existing organization applying after 5 years for renewal and organization applying, there would be a coterminous assessment power to assessment like power to the commissioner, and the commissioner is entitled to go into books, records, and reject if he finds. To our understanding, this is a very arbitrary power, because doing an assessment is a very complex process. In a 143(3) assessment, it takes a lot of time, and a fully focused assessing officer looks into it. But an authority as senior and as high as commissioner going into the books of account, it will be very difficult to pass rational and nice judgments, giving a opportunity of being heard to the assessing officer. So it may make increasingly difficult to get 12A registration unless the books and records and are kept in an absolutely fine order and there are no prima facie issues coming out of them.
Sir, also, once we read the new registration law, it provides that CIT and PCIT can check the genuineness of other laws as well while granting the registration. And this has also been discussed in this case laws that this is within the purview of commissioner to check for these records and compliance with the state laws as well. So how you see it?
Basically, if I read, this was always there, and the clarification came that state laws are applicable, but for the limited purposes of Section 11 exemption, Section 12A registration, whether the commissioner would be entitled to ensure compliance under those laws. So Supreme Court says it is basically non-compliance rather than compliance. If the commissioner notices non-compliance of any other applicable law, including state law, that can be a good reason for denying 12A registration. So it is rather non-compliance, any apparent non-compliance of other law, including state law. If it comes to the notice of the commissioner, it is not that the commissioner will sit on the chair of the state authorities and look into the compliance of the state law, but non-compliance of state law can also be a reason. And I can see that there are many trusts, to my knowledge also, which are registered in those states where there is a registrar of trust or a charity commissioner, and some of them are not registered with the registrar of trust, still have 12A registration. So this ruling is for those kind of entities, but it is prospective. So they may not have any direct impact, but that is what this ruling says.
And also after the Finance Act 22 amendment, they have empowered the commissioner to cancel the registration in such cases where there is a non-compliance with other laws.
Yes.
Now to sum up the ratio of judgments, which we have discussed, four ratios arising from the New Noble Education Society case, is for the word solely, that it is that solely is not the same as predominant and mainly. The term solely means to the exclusion of all others. But this solely word is only used in 1023(6). So I think this ratio of judgment is only applicable to 1023(6) NGOs and not to a 12AB registered NGO. But apart from this, all other three ratios shall equally apply to a 12AB registered NGOs. That is the ratio of judgment for what is incidental or education, the ratio of judgment for power to examine books of account by the commissioner, and the ratio of judgment for power to check compliance with other laws. I think all these ratio of judgment, though given for the case of a 1023(6) entities, but they shall equally apply for a 12AB registered NGOs. Tarunji, you can take up this.
Sir, I'm taking a few questions from the chat box. Since in the limitation of time, we will take as much as possible. Sir, what is the fate of trust having rental income from buildings or rent charge collections in the case of marriage halls?
Now, Yeah, Suresh, you can first continue, I will add.
Yeah. If the rental is only there, then the rental is the income from trust property. Rental itself is not a business activity. So my understanding is that if there is a rental income from the trust property, this will not be considered as a part of a business. This will be part of an income from trust property for the section 11, 12, 13 NGOs.
There is some more twist which is coming out of this case. Suppose you are having rental income. If you have created that property from your accumulated income with the intent of getting rental income, that will be under question mark after this ruling, because they are saying that if you are doing something, trust property which is for advancement of your objective, that can generate any kind of income. But if you are creating a property with the intent of making income, then it will take a character of business. So that is one. Organization may not invest their money, because to invest money you have to claim that it is a 11.5 asset. But 11.5 asset cannot be created with an intent to earn money. It should be an investment or advancement, a charity asset to an existing asset. An existing asset, incidentally, the Supreme Court, whether it is an unconscious error, I don't know. While talking about the business activity, it has said that if an educational institution rents out its premises for seminar to persons or institutions which are not related to objectives, it will not be treated as incidental business. So there is enough gray area. So I don't think, but an organization having a trust property which is otherwise required for advancement of objectives, and it will have rental income, I don't think it will be covered under 11.4 or 11.4a. But organization dominantly getting Kalyan Mandap income and other, then the Supreme Court ruling will be used by the department or can be used by the department, and it will take some tribunal or some body to decide whether you are entitled or not.
Sir, I think you have answered that question. Conference hall of a school is let out on rent to another school. Is it hit by this decision? So I think we have discussed that. Sir, another question which is coming, so I'll just ask the crux of it. Is this judgment only impacting the income side or also the application side? For example, if a trust is solely educational trust and it is giving a donation to the PM Care Fund, will that be considered as educational activity, or since the inter-charity donations are allowable application?
Now, look, this trust, this case law has discussed this Adityanar Supreme Court decision. Adityanar Supreme Court decision is only about inter-charity donation. So the case law has upheld the validity of advancing the activities either directly or through other institutions, and it has not passed any ruling detrimental to what has been done in past. So what is coming to my mind is that an educational institution can support another educational institution or a sponsoring body. There can be a sponsoring body and an university. So the court is not interfering into those models. But the question now is that can PM Care Fund donation be given by an educational institution? To my understanding, a strict interpretation would say no, because that is not absolutely education, because PM Care objects are not absolutely educational. And the PM Care Fund can do various activity, including education, but the court has taken a very categorical view. So Prime Minister Care Fund, solely educational institution, probably not. If the objects are similar, then probably yes. But these are coming as challenges. Normally, we don't relate charitable organizations with giving donations to national institutions. These are primarily used by individual donors and corporates. So it may not be a widespread problem, but it is certainly going to create confusion.
Sir, we have discussed about the surplus or profit arising out of incidental activities. But what if school charge fee from students? So will this ruling impact these institutions?
No. Fee from student is a collection as a part of advancement of normal activity. And if you are collecting fees and you are making profit, still no case for incidental business will come. These old rulings of TMA Pi and others will apply, where the courts have held that you are collecting reasonable fee and you are making some reasonable surpluses, which helps you to protect your corpus. Those rulings have not been disturbed. But if the fees charged are such that the income tax officer or the commissioner can argue that there is a dominant profit intent behind it, that is, you have to establish, for the first time in the judgment, the court has said the fee should be based on the cost. So while determining cost, normally capital expenditures are not allowed. So we have a habit of saying that our expenditure is such, then we have 100 crore of capital cost, but by using the word that determine the cost of services given to the beneficiary, cost plus markup, the markup may generate profit. That profit will not have any effect, provided if your markup is so high that it will no longer be treated as charitable activity, that you have a dominant profit meeting, you want to make profit out of your beneficiary. If that is evident, then you are not entitled for 12A registration itself. If the markup is high, suppose you are running 10 courses and in one courses you are charging very high to the students. One courses you are charging very high to the student, then the 7th proviso will apply. You maintain separate books of account. If you are a 1023C organization, if you have a 12A organization, you put that amount under 11.4A. Don't maintain the same income and expenditure account which you were doing in the past. And if that is a small component of it and it can be claimed as incidental business, then what we have already discussed. So this is how this ruling has to be implemented.
Sir, there are many questions. I think we have already closed the time limit.
Two, three important questions to take.
Sir, what is like incidental business activity? For example, it is school conduct exams of chartered accountancy or NEET in their classrooms. Will that be considered as incidental business activity for a school?
If you read this ruling, then this, if it is a business, then it is not permitted. It will not be an incidental business. But as we said, the rent from property, these are corpus properties of the institution and some reasonable rent is generated. I don't think the ruling intends to stop those kind of activities.
Sir, can these institutions have a dual activity like relief of poor and education as well after these rulings?
Yes, but under 12A, not under section 1023C. So that they have to be 12A registered organization or organization registered under 1023C, I think subclause IB, which is for general charitable institutions. So it should be under that.
Sir, if a religious and charitable trust collect a nominal registration fee from a general public for attending its events, will that be considered as a business activity and have impact on that registration?
It should not be treated as a business activity, as said that while implementing your primary object to cover the cost, if you are collecting fees, etc. So the covering the cost need not necessarily be from only your voluntary contribution or other income. You can collect from the beneficiaries also. But you collect more than the cost on the beneficiaries. Then the dominant profit motive will be done. So TMA 5, 6%, 7%, 8%, those kind of profit if you are generating. Up to that, it is charitable activity. Beyond that, you are not eligible for 12A registration itself.
So friends, we are coming with the 3 hours workshop on both these rulings in the first week of November. So we will discuss all these issues in the detail. This was just our preliminary observations and what we have come in just a one day. since the judgments come on the late night of 19th of October. So before concluding the session, I'll just ask a single liner key takeaway from both these rulings from sir, so that we can conclude the session.
For me, this one line is that all other impact, all other redefinition, etc., would not make any serious change to the normal way they have been functioning, but the constricting the definition of incidentality. Incidentality has become so narrow that virtually almost all organizations showing profit-making activity, whether as business or non-business, have to revisit, and many of them have to open up maybe separate institutions to take up their commercial activities.
Same. I think every NGO should now revisit their income stream. What is the source of their all the incomes, and then to identify which is the main activity or which is incidental, and then to take the appropriate step. So revisiting the income stream becomes the key from this judgment.
Thank you, sir, and thank you participants for attending in such a large number at such a short notice. Thank you, everyone, and you can register for the. We will come up with a detailed session on both these rulings in the first week of November. You can register for that, wherein we'll be discussing all these issues in the detail. Thank you. Thank you.
Thank you.